Good afternoon, everyone. Again, hi, this is Susanna Overholt, and David Josie and I are going to be giving you this presentation with the latest updates we've got regarding COVID-19, specifically those issues that we think are of most importance to the CMHCs. We're going to be talking about paid leave, work rules, and telemedicine today. As I said a few minutes ago, we are going to be taking questions at the end of the presentation. So as we go along, if you could type those into the chat function, we'll reserve time at the end to answer those questions. So I see that it's 12:30, so we'll get going to make sure we allow plenty of time here. Sorry, I got to make sure I click on the right slides. All right. So today, I mean, all of you, I'm sure, have been paying attention to all these kind of minute-by-minute developments with respect to COVID-19 and the pandemic. Federal and state authorities are continuing to issue guidance, waivers, and orders that affect your operations, HR functions, and how you deliver services in light of this pandemic. Today, we're going to be talking about recent developments relating to paid leave and workplace standards and requirements, federal and state pronouncements relating to telemedicine services, including Medicare and Medicaid reimbursement, as well as easing of HIPAA and Part 2 restrictions. And as I said, we're going to allow time at the end for questions as well as sharing practices by representatives from other centers, because we've got quite a few of you represented today, which is great. So first of all, you have all hopefully heard about the Families First Coronavirus Response Act, FFCRA, which is also known as House Bill 6201. It was announced, to make it clear this week, that it is effective April 1st of 2020. So we're going to be I'm going to give you a broad overview, talk about the exemption that can apply to employees who are healthcare providers, discuss the guidance from the Labor Department that came out this week, and also talk about the Paycheck Protection Program, which is part of the CARES Act that is supposed to be voted on by the House today. So with HR 6201, the major employer provisions are first that it expands FMLA, the Family and Medical Leave Act, by providing up to 12 weeks of job-protected paid leave to any employee who's been on the job for at least 30 days, and where that leave is related to the COVID-19 pandemic. And we'll get into the specifics of that. It also mandates up to 80 hours of paid sick leave for reasons related to COVID-19. The bill also provides $1 billion with a B, dollars in additional funding to the unemployment insurance system and encourages states to relax UI eligibility requirements. It also creates payroll tax credits for employers to help offset the financial cost of that paid leave. So the emergency paid sick leave under HR 6201 applies to employers with fewer than 500 employees and all government employers, and requires that all employees are provided up to 80 hours of paid sick leave if the employee meets one of 6 categories. So it's being subject to a federal, state, or local quarantine or isolation order, related to COVID-19, and all of these obviously are supposed to be related to COVID-19. If the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, or if the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. It also applies for this paid sick leave if the employee is caring for an individual who's subject to a quarantine order or a self-isolation order, is caring for a son or daughter if the school or child care location of that son or daughter has been closed, or if the child care provider is unavailable due to COVID-19 precautions, or if the employee is experiencing any other substantially similar conditions specified by CMS in consultation with the IRS and DOL. Now, that last one is one that needs a little direction, and I think that could be a bit of a catch-all there, but we'll talk about that a little more. But these are the categories that qualify for that emergency paid sick leave. So the first three categories, so the quarantine, having symptoms, seeking diagnosis, or being isolated at a doctor's recommendation, those days are paid at the employee's regular rate of pay. However, the leave is at 2/3 the employee's regular rate of pay if the leave is for the reasons 4 through 6, which is to care for someone else, to care for a child, or if the employee is experiencing a substantially similar condition. So full-time employees get 2 weeks, up to 80 hours of paid leave, and part-time employees are entitled to the average number of hours that they work in a typical 2-week period. This leave has to be provided in addition to any paid time off that may be provided under an employer's existing policies or other local or state mandates, and you may not require an employee to exhaust existing accrued paid time off before using this emergency paid sick leave. Now, the expanded coverage under the FMLA applies or provides up to 12 weeks for employees who are employed for 30 or more days by an employer with less than 500 employees or any public sector employer. Now, this expands beyond the normal FMLA requirements. So normally the FMLA does not apply to much smaller employers. This again is for employers if you have less than 500 employees. The other thing is that for the normal FMLA provisions, the employee has to have been employed for a year with certain minimum hour requirements met. And again, this is taking that down to the employee only has to have worked for you for 30 or more days. So that's just something to think about. But it is only expanding FMLA for this very limited purpose, which is the job protected leave to care for the employee's child if the child's school or place of care has been closed or the child's ordinary child care provider is not available due to COVID-19. So that's the only circumstance under which this expanded leave applies under the FMLA. Otherwise, the normal FMLA rules apply and the normal reasons for FMLA leave apply. So it's just this one child care provision due to the school being closed or, the child care not being available. So while the first 2 weeks of time off under this expanded FMLA provision are unpaid under the FMLA, the emergency paid sick leave that I just discussed requires that an employee be paid during that time period. So what that means is if an employee needs time off to care for a child who's, again, school's closed, child care is closed, they get that emergency paid sick leave. That covers them for the first 2 weeks under this FMLA leave. And then after those first 2 weeks, employees are entitled to receive 2/3 of their usual rate of pay. So this is a paid leave, which again is different from the normal FMLA. So one of the things that is applicable to CMHCs is that there is a healthcare provider exemption under the FMLA provisions of HR 6201. And that exemption allows an employer of an employee who is a healthcare provider to exclude such employee from the leave provisions. Now, the Act does not provide any new definition of healthcare provider other than what is already contained in the FMLA, and that is a fairly narrow definition. So the FMLA defines a healthcare provider as a licensed doctor of medicine or osteopathy or any other person determined by the Secretary of DHHS to be capable of providing healthcare services. Now, at this point, there is Department of Labor guidance that has defined others capable of providing healthcare services. Again, this is for purposes of the traditional FMLA, but it's all we have to go by right now. And so normally, and I've highlighted in bold the positions that would generally apply to the CMHCs. But so those provided, for your purposes, clinical psychologists, nurse practitioners, clinical social workers, and physician assistants. The exemption, now, so this would all apply to the FMLA provision, and it does not apply to the paid medical leave, the paid sick leave provision. However, the Department of Labor may create an exemption under that leave, and you know the DOL has been issuing kind of different guidance each day this week, so there may be something still issued, and we'll keep our eyes out for that and let you know. So the impact of this healthcare provider exemption is that a CMHC cannot exclude all employees from the leave just because the CMHC is a healthcare provider. You can exclude providers who are specified in those preceding slides, so that'd be the MD, the psychologist, NP, the social worker, the physician's assistant, from the expanded FMLA provisions, which again, that's the child care provision. But your other employees, whether they're RNs, administrative staff, finance staff, I mean, those people would have to be given the opportunity to take the leave. You cannot exclude them. So another aspect, and I know this may not apply to many or any of you, but employers who have fewer than 50 employees can be exempt from the expanded FMLA coverage if they meet a viability exception. And again, the DOL is going to be issuing guidance on the process for claiming that exemption, and we haven't seen that yet either. So one of the benefits attached to this paid leave is that Congress has created a payroll tax credit that is supposed to help cover the expenses of this leave. So the tax credit is applied to the employer portion of the Social Security payroll tax that would be equal to 100% of the sick leave and family leave wages paid for each calendar quarter, subject to some caps. So the sick leave wages for those categories 1 through 3, which are the self-quarantine or to obtain a diagnosis or care, those wages are capped at $511 per day. The sick leave wages for the other 3 categories, which was to care for a family member or a child or for another similar condition, are capped at $200 a day. And then the leave wages under the expanded FMLA are capped at $200 a day and $10,000 for all calendar quarters. If the credit exceeds the employer's total Social Security payroll tax liability for any calendar quarter, that excess credit is refundable to the employer, and employers may elect to not have the credit apply. And on top of this, although this probably doesn't apply to any of you, but it's something very novel here, is that a similar refundable tax credit is available for self-employed individuals. So one of the major concerns that employers might have here is that it's really, this is a pay now, get relief later situation. So you're going to be paying people who are on leave, you know, obviously while that's happening, and you won't get relief until the next quarter, basically. So the DOL did issue guidance and it actually addresses a lot of the questions we've been receiving about how these provisions work. So first, employers may give employees the option to supplement or adjust the pay that's mandated under the FFCRA or HR6201 with other paid leave but can't require it. So when the employee, if they're under that 2/3 pay rule, or you know, if the capped wages aren't sufficient and there is, you know, PTO or something, if the employee wants to supplement the federal leave with some other leave to increase their pay, they can choose to do that. And employers, you know, you can give the employee the option to do that, but you cannot require that the employee do that. It's got to be the employee's choice. And these leaves, these new leaves, the sick leave and the expanded FMLA leave, are in addition to any pre-existing leave entitlements that the employee may have under your policies. Now, the other thing, the flip side, and I think I said this, but to emphasize this, is that you are not required to allow an employee to use the existing paid leave to supplement the federal mandated leave. So you don't have to allow it, but if you do allow it, you can't require it. So just some other things is that overtime hours need to be included when calculating what the employee's regular rate of pay is. And then the emergency paid sick leave only requires that leave be paid up to 80 hours over a 2-week period. So you look at the total that's issued over the 2 weeks, and it's not that it has to be 40 hours a week, it's just up to 80 hours over those 2 weeks. And an employee may not take 80 hours of the paid sick leave for personal self-quarantine and then another amount of paid sick leave for another reason. So they get one 80-hour block, and that's it. So the expanded, looking at how this works with the expanded FMLA, is that eligible employees may take both paid sick leave and expanded family and medical leave to care for a child whose school or place of care is closed for COVID-19 related reasons. And that, as I said, that initial 2 weeks of paid leave under the Emergency Paid Sick Leave Act can cover, or does cover, the first 10 work days of the expanded FMLA, unless the employee elects to use other paid leave, which they can choose to do. So one of the questions, is that everyone's been trying to sort through these regulations and what they mean, and one aspect of the guidance that DOL issued, I think it was yesterday or the day before, is that it is not going to be bringing enforcement actions against employers for any violations of these provisions that occur within 30 days of the enactment. So basically now through April 17th of 2020, if the employer doesn't quite get it right, the DOL is not going to go after the employer, and the standard is that the employer must have made reasonable good faith efforts to comply with the act. So if you're making decisions based on your reading of the act, and if they're reasonable and in good faith, even if they turn out to be wrong, you're going to be okay through April 17th. And I think the reason they put that 30-day kind of benchmark there is because the DOL keeps coming out through guidance, and hopefully coming out with guidance, and hopefully by April 17th, it'll be less murky. I was going to say clear as mud. I mean, it's clear as mud now, but hopefully the mud will not be as thick by then. So employers act reasonably and in good faith if the following facts are present. So the employer remedies any violations, including making all affected employees whole as soon as practicable, the violations were not willful, and if the DOL receives a written commitment from the employer to comply with the act in the future. So something else that we've gotten questions about is questions of furlough versus layoff versus the loans, the loans that are available in the CARES Act, if it is approved as anticipated. So layoffs are termination events, and employees, if you lay off an employee, they're eligible for unemployment insurance benefits and all their earned wages at the time of separation. So, accrued PTO, all that good stuff. A furlough is generally a situation where it's the individual's employment remains intact, but normally an employee would not be entitled to unemployment insurance when they're on furlough in Indiana. But under Governor Holcomb's executive order, an employee who is on furlough is eligible for unemployment benefits, even though the employment relationship hasn't been severed. So if you're in a situation where you feel you need to furlough, meaning kind of place employees on a temporary out-of-work status because there's no work for them to do, you can do that, and they can apply for unemployment. Now, the other thing is that with respect to the loans, that the CARES Act creates a loan system for employers with fewer than 500 employees, and it's called the Paycheck Protection Program, and that what that loan is it would, especially for CMHCs, I mean, there's a $10 million cap, I'm assuming, for an 8-week period, so I'm assuming that you all aren't probably close to that. But the loan is limited to the sum of your average monthly payroll costs for the 1-year period ending on the date the loan was made, multiplied by 2.5. So 250% of your monthly payroll costs. And then, of course, it defines payroll costs, and that's your, your wages, payments for leave, any, if there's, separation payments or something, or payments for benefits, retirement, health benefits, retirement benefits, and then taxes. The payroll taxes do not include compensation of any individual employee in excess of an annual salary of $100,000, so you can include them up to $100,000, but not over that. Does not include payroll taxes, does not include compensation. Again, this shouldn't apply, I don't think, but if the employee has a principal place of residence outside the U.S., and also doesn't include the qualified sick leave or family medical leave for which you would be getting a credit under HR6201. So the good thing is that a portion of these loans can be forgiven on a tax-free basis, and the amount to be forgiven is actually the sum of the payments made during the 8-week period that are made up of payroll costs, mortgage, rent, utility payments, so kind of your payroll costs and your overhead. So if you take out the loan, I mean, if you take it out, so just even Steven with these expenses, and that it can be forgiven for those expenses. And to seek forgiveness, you would have to submit an application that includes documentation verifying the number of employees and the pay rates, and provide proof of payment essentially. And the amount that could be forgiven might be reduced if you reduce your workforce during the covered period or reduce the salary of individuals earning less than $100,000 a year by more than 25%. However, that reduction can be avoided if you rehire the individuals or increase, the compensation that was reduced. Something I want to touch on real quickly, something else about the CARES Act, though, is that if you do take one of these loans, if a union were to try to organize your employees, that you would have to remain neutral during the organization effort. And one other thing that came out today is that DOL did issue guidance regarding documentation requirements, and they're pretty much what you'd expect for an FMLA type leave, that you have to, have the employee's name, the qualifying reason, why the person is unable to work or telework. And I should say, actually, for these leaves, that those 2 leaves apply if the employee, if they're unable to work or telework, then they're entitled to those leaves. But we will be sending out something that contains a little more detail about those documentation requirements. That's an example of something that just came out today. So now I'm going to turn it over, to David, who's going to start talking about telemedicine and Medicaid. And David, you might need to unmute your phone. It was saying just a minute, we're having technical difficulties. Hold on, please.
The next slide. Getting
I will be with you in just a second. We apologize.
Okay, sorry about that. I'm now in Susanna's office because I had a technical meltdown there. Telemedicine and Medicaid. The governor's order that went into effect on March 6th actually relates back to March 1st for purposes of Medicaid and telemedicine. One of the interesting features in his order is the statement about authorizing any other agency to seek and accept any funding or other resources from any entity, government, or private to treat, control, or stop the spread of COVID-19. And so telemedicine gets a lot of attention both at the state and federal level, and so we wanted to touch upon that. Some of the distinctions that are present between Medicaid and Medicare also. For purposes of Medicaid, it covers all sorts of mental health services, community-based, home and community-based services. It's also important to note that it expands the type of technology that can be used. It does require real-time interactive, consultative technology, but it allows voice-only communication, so this can be done over the telephone. Does not permit text or email because that's not an adequate form of interactive technology for Medicaid purposes. One of the interesting features is the reference in the bulletin BT 202022, which was issued March 19th. Excuse me, I need to mute my cell phone, is the reference to appropriate consent prior to the services. And when you look at that term, it is similar to the term that's used in the provider manual or module for Medicaid services. Talks about appropriate consent having been secured. When you look at the Indiana Code, it requires consent prior to mental health services, but it doesn't specify whether it has to be written. So presumably it would permit verbal, but obviously best practices, everyone's practices are to require written consent. One of the things that you are going to want to look at as part of this process and coming out of this emergency situation is whatever your protocols are associated with securing consent and how that is documented. But when you look at, for instance, other sources, the MRO manual, I think, provides some assistance here. I know that some of you have been concerned about how we document consent, patient's consent for whatever the telehealth service might be. It acknowledges the possibility that you won't secure the consumer's written signature on a treatment plan. It has a protocol that you need to follow if the member is refusing to sign the treatment plan. From my perspective, that's an acknowledgement. There are also some other bits and pieces of pronouncements that we've seen that acknowledge that in this situation, you may not have the same degree of written documentation of a patient's consent or a patient's involvement that you ordinarily would have or that auditors 2 years from now might be looking for. But I believe that the executive order and the pronouncements from Medicaid and other sources will allow you to finesse the written consent requirement for the telehealth services. But if you are providing those, you're going to want to document, time and place and manner for the services. Next slide. Telemedicine and Medicare. This is based upon a pronouncement from CMS indicating that they are going to be covering telehealth services as of March the 6th. Previously, Medicare would only pay for telehealth services if it was to a patient in a designated rural area who then goes to a specific medical facility site. Now, CMS is expanding that location. It's allowing both for it to be provided by centers in terms of typical inpatient services. It permits the services provided by physicians, nurse practitioners, physician assistants, clinical psychologists, and clinical social workers. Again, in terms of worrying about the audit and what type of prior relationship one might have had, for Medicare purposes, they've explicitly said that audits will not be used to confirm a prior relationship with that patient for purposes of Medicare payment. There are different types of telehealth services. There is the typical interactive health service. There are also virtual check-ins and e-visits. The virtual check-ins allow for a response to a patient, and in that situation, again, it acknowledges verbal consent by the patient as an acceptable form of consent for the service. So that has gone into effect for Medicare. Then telemedicine and HIPAA. And we have to be a little bit careful here because, as you all know, mental health records in Indiana are treated more stringently. They're protected more than HIPAA might require. But I think that we can follow the Office of Civil Rights lead here in terms of what HIPAA is allowing, or what actually the Office of Civil Rights will allow in exercising its discretion, which is what has taken place. They've announced that they will exercise their discretion in a way that they will not be enforcing or penalizing violations of HIPAA's privacy, security, or breach notification rules during this period of emergency. It acknowledges the increased use of a variety of telehealth technologies. It does require, though, that the provider exercise good faith. It's framed in a way of saying that they still will pursue enforcement if they see signs of or evidence of bad faith. And so that would suggest that the provider is not taking reasonable precautions in terms of the devices that are used, the available technology for encrypting that could still be available. It doesn't permit willy-nilly violations of HIPAA's requirements, but it certainly provides flexibility. Now, one of the things that the Office of Civil Rights issued related to disclosures to law enforcement, and that was done as a means of not really expanding the ability of providers to reveal even more to law enforcement, so much as it was a reminder that providers still have obligations and limitations in terms of what can be shared with providers. And again, given that Indiana is more stringent in what it allows to be disclosed to law enforcement officials for mental health records, let alone for substance use disorder records, you still need to be very cautious and not assume that this emergency allows even greater disclosures to law enforcement personnel simply because of the COVID-19 emergency that we have. Furthermore, we've got to be concerned about the fact that COVID-19 might be considered a communicable disease, and there are special precautions associated with disclosure of information about people being treated for communicable diseases. So that's another overlay. Ultimately, what is being said here is, again, at the federal level as well as the state, we want to encourage the use of telemedicine. We don't want HIPAA potential violations to be a deterrent to the use of telehealth services and expanding the technology that you all are using or considering using. The one point that OCR made clear was they have responsibility for HIPAA and not for 42 CFR Part 2 programs that, as you know, have special requirements associated with consent for disclosing and redisclosing health records. This is an issue that the CARES Act legislated on, and I think will reinforce perhaps on a more enduring basis. I want to dig a little deeper into this over the next 2 days, but SAMHSA was pointing out in its announcement on March 20th that they want to encourage, again, the use of telehealth services because of the susceptibility that a lot of substance use disorder patients have for COVID-19. They want to encourage the use of telehealth services, which will expand the availability and their availability to get it from distant locations. They have said that as long as you have a pre-existing consent from a patient, that will be sufficient for the disclosure of Part 2 records to other providers for healthcare treatment, payment, or other healthcare purposes, and will permit that party to whom you've disclosed the records to, in turn, redisclose the records as necessary for treatment, payment, and other healthcare purposes. So they want to, again, encourage integrated care. They want to encourage coordinated care. They want to encourage telemedicine, and they're basically lowering the barrier that they recognize exists for the Part 2 records. This is one of the more interesting features in the SAMHSA news release about this, the bulletin they issued. They actually put in bold letters emphasizing how even under the Part 2 regulations, it allows for an exception for medical emergencies. And so they want to underscore for providers documenting the emergency circumstances that you're operating under and how that is justifying the disclosure and redisclosure of your consumers' records for treatment purposes. Next is miscellaneous items. A few items. Matt Brooks will probably be in communication, if he's not already, with you about the increased FMAP being provided to states or being made available to states, a 6.2% increase to help cover Medicaid's match that may have some positive impact for you, may permit you to extend services further or to cover some of the revenue loss that you're going to be experiencing during this emergency. Matt mentioned to me, and I clearly recall how the state didn't shy away from encouraging the provision of services back during the recession of 2008 and its aftermath when there was support provided, and then the state simply terminated contracts immediately and refused to pay for services already provided under that increased reimbursement arrangement. DEA is allowing controlled substance prescriptions based upon telemedicine visits even without a prior in-person visit. This aligns DEA's position with Indiana law that now allows for prescriptions of controlled substances without an in-person visit. The last point is OIG's waiver of the anti-kickback statute scrutiny when waiving copays and deductibles for telehealth services. Again, there is a lot of encouragement, and it was reiterated as part of the CARES Act, for increasing telehealth services, and this was something anticipated by the OIG a couple weeks ago by basically saying, if you want to waive copays and deductibles in order to encourage your consumers to receive telehealth services, then you can do that without concern that that might violate the anti-kickback statute. So that is another important change, and it's again a recognition of the desire to increase telehealth services at both the federal and the state levels. So we've oh my goodness, we've covered a lot of territory. Susanna covered it in breakneck speed, covered a lot of details, but we wanted to have enough time to allow for questions to come to us through our coordinator, and we will try to answer them. If you have any suggestions that you want to share with other centers for how you are responding in difficult situations, this is an opportunity to share some best practices as well.
All right, so I'm looking at the questions. We've got so one of the questions is, do you think the Department of Labor will apply the integrated employer test to an employer that asserts it is subject to these new provisions? We're part of a network of 3 separate corporations, each which are less than 500, but collectively greater than 500. So my understanding and what we've reviewed internally so far is that the same rules that apply for determining the size of an employer under the FMLA would apply here, and that, yes, the integrated employer test, we think, does apply to this. Thank you for that. So the other question, another question is, can we also cap what we pay the employee, such as $511 per day, not just cap the credit? The provisions state that they are supposed to be paid, so that I think the answer to that is no. The employees are to be paid at their regular rate of pay, and the guidance, as I mentioned, that includes overtime wages, for example. So the amount of pay that people receive while they're on these two types of leave, that needs to be based on their regular wages, but it is the credit that is capped. So the next question, the largest population for CMHC workforce is case managers, skills trainers. Under what category do they fall? And I think that question has to do with whether that person would be considered a healthcare provider. And with what we have right now in terms of the existing FMLA regulations and existing Department of Labor guidance, is that I don't believe those individuals would count as healthcare providers. So they, the license, the license, it's not all about license, but yeah, I mean, I think that's, so what that means is that they would have to be granted that that expanded FMLA leave if they qualify. And I do want to emphasize too that although I guess that probably isn't maybe going to help too much with your case managers and skills trainers, but that the expanded FMLA and that sick leave apply if the employee is unable to work or telework. So if the employee could work from home while taking care of the kid whose school is closed, then they don't have to be granted the leave. They can telework instead. I think this is for you, David. So the next question says, but we heard Medicare will only pay $13.92 per event.
I haven't heard that. I don't know what type of an event that would be that they would limit it to. The other thing that I haven't tied down yet and hope to find a better anchor is whether to bill, if you have hospital-based locations where you bill provider-based as opposed to physician office or an independent office-based, whether that is billed as a hospital-based service with a facility fee even for the telehealth service. I saw a footnote that suggested that it would be based as a facility-based service, even though it's a telehealth service and presumably from the practitioner's office, and not incur the facility expenses associated with provider-based billing. So I don't know what limits Medicare has put on how much they will pay for any particular event yet. Can you verify telehealth PPS billing for both Medicaid and Medicare, or will it be fee-for-service in regards to our FQHC staff working at home? That, I think, is tied in with what I was just talking about. The CARES Act has some provisions specifically directed towards FQHC services, and so I will dig deeper into that to see whether that provides any answer to that question. Can the 80 hours of emergency leave be taken over a longer period of time than 2 weeks?
No, that is really meant to be a block of time, and it also, as I said, so it can be a standalone block of time, or it can be if someone is seeking the expanded family and medical leave for purposes of the child whose school is closed or child care provider is closed. It covers the first 2 weeks of that. But yeah, it's intended as a single block. And then, sorry.
Medicare, does the expansion of telephone delivery of services void the 1 in 3 rule, which is limited consecutive telepsych video visits? I've not seen anything on that specific point. The only thing that I've seen is that you can't have a face-to-face or an office visit with that person either within 7 days prior to the telehealth service or within 24 hours after the telehealth service. So I will look for anything more, but I've not at this point seen anything on the 1 in 3 rule.
Okay, so this says, Susanna, review the poster that just came out from Department of Labor. It states employers must provide employees based on the higher of their regular rate of pay, paid at 100% for reasons 1, 2, 3, up to $511 daily. Okay, I'll take a look at that. I'll take a look at that language. Thanks for pointing that out, and we'll get back to you on that. All right, another question. Pause long enough and another question pops up. You guys are great. How do you suggest we handle doctor's notes that say employee cannot come to work, however, they're not positive for COVID-19? We're seeing a large increase in these generic doctor's notes over the past week. I would actually say treat those as a regular, I mean, if it doesn't mention COVID, well, first of all, they don't have to be positive for COVID-19. So I guess that's one of the things to be on the lookout for. If it's, you know, that sick leave, one of the provisions, if I can get back to that slide, sorry to make you all dizzy by doing this so quickly. It's a question of if they have symptoms and are seeking diagnosis. So that's the experiencing symptoms of COVID-19 and seeking a medical diagnosis. Now, so I think you need to be a little bit careful. So it's not that they have to test positive, but if they're seeking a diagnosis, that would qualify them for the leave. It's also a question of whether a doctor has told them they need to self-quarantine due to concerns related to COVID-19. But if you're just getting a doctor's note saying that Susie Smith needs to stay off work because she's sick, that I would not accept that as enough to get this emergency paid sick leave, and I'd treat it under your regular policies. So the next question, and I saw a discussion about this earlier today, can the expanded FMLA be used similarly to intermittent FMLA, or does it also need to be taken in a block of time? My understanding is that it's a block of time, but we will double check that. Yeah, my understanding is that it is a bit different in how this works, but as I said, we'll follow up. What kind of documentation can we or should we ask for if someone needs to be off? So this is the thing I breezed through really quickly because I thought we'd be out of time, but I will. So the DOL guidance that came out today says that for the documentation requirements for the expanded medical leave and the emergency sick leave would be the employee's name, the qualifying reason for the leave, so one of these 6 reasons for the emergency paid sick leave or the reason under the child care provision of the expanded family medical leave, a statement that the employee is unable to work or telework, because again, if they can telework, they aren't entitled to the leave. But it's a statement that the employee can't work because of this reason necessitating the leave, and then the dates for which the leave is requested. The documentation needs to show the reason for the leave specifically, and I was speaking with someone yesterday about possibly, creating a form that has a checklist on it. And then you need to comply with any IRS documentation requirements for the tax credit. And going back to the reason for the leave, that should include the source of any quarantine or isolation order, the name of the healthcare provider who advised the self-quarantine, and then a copy of any, the notice of the school or daycare closure. And that can be an email from the school, it can be, something that was widely advertised, something like that. So that's the documentation so far. And and then also that anything else that IRS might normally require in order to qualify for a tax credit. Okay, so the next question is, do you know the reference to the Indiana law regarding prescribing controlled substances over telehealth?
It should be under Indiana Code 25-1-9.5.
Okay, and I think with that, we've reached the end of the questions. Those were great questions. What we're going to be doing is sending out a follow-up email that will actually have the slides that we covered today in that email, and there will be a link to our website. We have on our website a bunch of COVID-19 resources. We've been producing a lot of material addressing questions regarding COVID-19 and all this guidance that's coming out. So keep an eye. We'd encourage you to keep an eye on that. And as always, feel free to reach out to us if you've got any other questions. And as things develop, if it seems like it'd be useful, we'll provide updates as appropriate. So thank you all so much for attending. I don't know, David, if you had any final words of wisdom.
Just two comments. One is the COVID-19 site on our website that I forwarded, I know, to the CEOs, has especially a lot of practical information in the employment area. And just as Susanna ran through a whole lot of stuff today, that provides a whole lot of kind of real-time advice on some of these specific areas. The second thing is, if you have follow-up questions, obviously don't hesitate to call or email us, or contact Bennett, and he can be the conduit and forward any questions on to us, and we can get answers back to you through him. So that can also work so that everybody's staying up as close to real time as possible. So with that, thank you all very much, and stay healthy.
And dry, since it's raining an awful lot today. Seems appropriate for the situation going on right now. But, all right, thanks so much. Have a good rest of your afternoons and a good weekend. Bye.